Consistent with our convention obligations, the U.S. brought legal action to remedy these abuses, which resulted in the 3 largest residential lending discrimination settlements in the Justice Department's history. We know that law enforcement is dangerous work, and most police officers are dedicated public servants. With this in mind, the division has worked hard to produce sustainable models for effective, non-discriminatory, and constitutional policing and prison systems. Over the last 5 years, we have achieved 14 groundbreaking reform agreements with police departments all across the United States to address excessive use of force and racial profiling. Also criminally prosecuted 337 officers for misconduct during this same period. And we are working to improve conditions in America's prisons, examining, for example, the overuse of solitary confinement, and to safeguard the rights of youth in the juvenile justice system. The Justice Department also is aggressively prosecuting hate crimes. As a longtime federal prosecutor myself, I can tell you firsthand that the devastation caused by a single act of hate can reverberate through families, through communities, or through the nation. No one should have to sleep less easily at night or live in fear that they too might be attacked simply because of their skin color, the country they were born in, their faith, or whom they love. In 2009, we gained a powerful new tool to combat hate crimes when President Barack Obama signed into law the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act. Armed with this new tool, the Justice Department prosecutors over the last year had convicted over 160 defendants on hate crimes charges, amounting to nearly a 50% increase over the previous 5 years. I have described for you just some of the Justice Department's work in America's founding documents of equality under law. We are proud to stand with our fellow agencies in our collective responsibility to fulfill our nation's obligations under the Convention, as well in our shared moral responsibility to eradicate discrimination and ensure equal justice for all. It is now my pleasure to introduce our next speaker, Catherine Lehman, the Assistant Secretary for Civil Rights at the U.S. Department of Education.
Members of the committee and representatives of civil society, I am Catherine Lehman, and I serve as Assistant Secretary for Civil Rights at the United States Department of Education. The mission of the Office for Civil Rights is to ensure that our nation's students receive equal educational opportunity in schools with respect to race, sex, color, national origin, age, and disability. So my remarks today will focus on equal educational opportunity for all of our nation's students. On my colleagues from across the United States government, we are honored to be here to share our work to eliminate racial discrimination and uphold our obligations under the Convention. My colleagues and I strive to eradicate all forms of racial discrimination in our society, fulfilling President Obama's promise to deliver, quote, the promise of opportunity, defend our fellow Americans' sacred right to vote, seek equality in our schools and workplaces, and fight injustice wherever it exists. Racial equity is an important part of the Department of Education's mission. Today's discrimination impacts of racial and ethnic backgrounds, including Black students, Latino students, Native American and Alaska Native students, and Asian American, Native Hawaiian, and Pacific Islander students. Racial discrimination can also intersect with other forms of invidious discrimination, including discrimination on the basis of disability, sex, age, sexual orientation, and gender identity, as well as distinctions drawn on the status as English learner or immigration. The department vigorously enforces federal civil rights laws in all aspects of the educational system, from preschool to post-secondary education, and in career, technical, and adult education. To take one example, in 2011, my office reached a resolution with the Los Angeles Unified School District in California, which is the second largest public school district in the United States, serving more than 640,000 students. The district had before then had racial disparities in its school discipline practices that resulted in lost learning time for many students of color. My office partnered with the district to develop and implement a comprehensive plan to eliminate the racially disproportionate discipline of Black students. Since then, the suspension rate in that school district fell to 1.5%, and the suspension rate for Black students has been reduced by more than half. The Departments of Justice and Education have partnered to reduce racial disparities in school discipline practices more generally across the nation's schools. The United States also works to ensure that all students have access to high-rigor courses. For another example, the Cleveland Metropolitan School District in Ohio had very low enrollment at innovative schools that focus on science, technology, engineering, and mathematics, because the district did not distribute relevant information in Spanish, which is the home language of 80% of the district's English learner students. Through a resolution agreement with the school district, my office is working to ensure that the district reaches out to Latino families and does a better job to identify and assess the barriers to less students' participation in these creative programs. In addition to our enforcement efforts, the department provides policy guidance to proactively assist educational institutions in their compliance with civil rights laws. For example, in 2011, we published guidance that advises elementary and secondary schools on how they may reduce racial isolation and how colleges and universities may voluntarily pursue racial diversity consistent with the law. We've also issued policy guidance related to the equal right of all elementary and secondary school students to an education regardless of their or their parents' citizenship or immigration status, as well as guidance on the obligations of schools at all levels to respond to bullying and harassment based on a student's race, color, or national origin. Thank you for the opportunity to talk about our work to reduce racial discrimination in our nation's schools. I know my fellow federal agencies that are not speaking today also look forward to providing similar information to the committee about the range of programs and authorities they use to combat racial discrimination in the United States consistent with our convention obligations. I'm now privileged to introduce a great leader and local partner of the department, Attorney General Dustin McDaniel from the state of Arkansas.
Thank you. Thank you, Mr. Chairperson and distinguished members of the committee, representatives of civil society, ladies and gentlemen. My name is Dustin McDaniel, and I am the Attorney General of the state of Arkansas. I am honored to participate in this delegation. On behalf of governors and attorneys general throughout the United States, I am proud of our tremendous progress towards the implementation of the goals of the convention. Of course, there is still much work left to be done. Attorneys general work with each other and with our federal partners so that our states may ensure equal economic and educational opportunities and to combat all forms of racial discrimination. We recently concluded historic litigation designed to discriminatory access to housing, consistent with Article 5(e)(3) of the Convention. When the United States housing market collapsed, a pattern of fraudulent mortgages that targeted homebuyers who were unable to repay their debt was exposed. A global economic crisis followed, and more than 4 million American families lost their homes. Along with U.S. Attorney General Eric Holder and then Secretary of Housing and Urban Development Sean Donovan, My fellow state attorneys general and I reached a $26 billion settlement with America's 5 largest banks related to mortgage fraud. Minority borrowers were specifically targeted and disproportionately impacted by this fraud. They were more than 70% more likely to lose their homes to foreclosures than non-minority borrowers. To date, the settlement has resulted in more than $10.7 billion in principal reductions, allowing families to stay in their homes. My administration has set a national standard for prohibiting short-term cash advance lenders, commonly called payday lenders, who target minorities, veterans, and the elderly. I am working closely with the recently created Consumer Financial Protection Bureau to create a national standard to regulate these predatory lenders. The states also work with the U.S. Department of Education to ensure equal educational opportunities consistent with Article 5E5 of the Convention. In the United States, some colleges are now operated by private corporations. Their primary goal is making a profit rather than providing a quality education. Some of them target minority students and make false representations about graduation and job placement rates. Students are often left with significant debt and no income. I, along with 24 other state attorneys general, am investigating the fraudulent and deceptive practices of these corporations. Access to primary and secondary education is critical for all students. Therefore, I focus significant resources to education litigation designed to use our court system to end and remedy a shameful history of racial segregation and an inherently unequal school funding system. Almost continually since 1957, federal court litigation intended to desegregate public schools has been ongoing in Little Rock, Arkansas. This year, the court affirmed the legal and moral accomplishment of ending segregation in our schools. The litigation solidified the state's commitment to non-discriminatory policies ranging from student assignment to discipline. We also resolved decades-old litigation in the state court system, challenging state funding of schools in poor rural areas, which often had significant minority populations. Decades of poor policy led to inadequacies that disadvantaged minority and underprivileged students. Today, that litigation is over. Our state constitution and the convention are being upheld, and Arkansas's education policy now ranks 5th in our nation, according to Education Week's annual Quality Counts report. Our law now establishes student foundation funding. That means that education funding no longer is exclusively tied to property taxes. Pre-kindergarten education for 3- and 4-year-olds provides a substantial advantage to minority students. Arkansas now has one of the best pre-K programs in our nation, providing nearly universal access to pre-K education for low-income and minority students. And one candidate for governor has made its expansion a key issue for our future. We are proud of the work that we have done in these areas and many more. I look forward to answering your questions, and I sincerely thank you for allowing me to appear with this distinguished delegation today. And it is now my privilege to introduce the Mayor of Birmingham, Alabama, the Honorable Mayor William Bell.
Thank you, Mr. Attorney General. To the Chair and distinguished members of the committee, I'm William Bell. It is my honor to come before you as the 33rd Mayor of the City of Birmingham, Alabama, in the United States. Just 50 short years ago, our city was part of the segregated South. Brave men and women cried out for equality, and the world listened. Today, our city is a thriving example of what change brings. With over $1 billion of capital projects over the last 5 years, a thriving university, a biomedical center, and an effort to establish ourselves as the civil rights center of the United States, Birmingham stands as an example of what citizens can do when they come together in unity and with a singular purpose in mind. I am privileged to be here today to speak to what local and municipal governments have done and continue to do to eradicate racial discrimination in our cities. A few of the programs we have put in place deserves particular mention. For example, we have created civic reintegration after incarceration programs within our municipal court systems, incorporated human rights curriculums at all levels of our public schools, and have worked with our colleges and universities to successfully encourage them to offer human rights studies programs so that all of our young leaders and graduates all of our young leaders who graduate will have an awareness of human rights issues around the world. Birmingham is a changed city, thanks in parts to programs and initiatives that continually remind us that the fight for equality is ever present. Mr. Chairman, having been born into a segregated society, having seen all of the changes that have occurred over the past 50 years, primarily through the work of brave men and women who sacrificed and put their lives on the line, I know that change can come. It has been referenced earlier about the passage of the Civil Rights Bill in 1964 and the Voter Rights Bill in 1965. I am a direct result of the initiative that was taken by our federal government to ensure that all of our citizens be treated fairly and equally, and that all of our citizens have access to the ballot box and can fully participate in the electoral process. I stand ready to answer any question that you might have about our local initiatives and how they fit into the overall efforts of the United States to ensure that everyone is treated with dignity and fairness, no matter what their station in life might be. Thank you.
Agradezco mucho.
I'm very grateful to the distinguished delegation of the United States for the presentation we've just heard from them. At this stage, as I said, I will turn to the country rapporteur, Mr. Amir, and I would call upon colleagues of the CERD to register, put their name down to take the floor later on. So the list of speakers is now open. But first, turning to Mr. Amir, our country rapporteur, as you will be aware, we have time limits, but do take your time though, sir. Don't hurry too much. So take your time, but not too much time, so that we have enough time later on for questions and answers from the delegation. So, Mr. Amir, you have the floor, sir. Go ahead, thank you.
Thank you, Mr. Chair. Thank you for these very kind words of you regarding the due time to be given to me and present my statement. Mr. Chair, I would like to extend my warm welcome to the large and high-level delegation of the United States of America and express my appreciation for the high quality of the combined 7th to 9th periodic report of the State Party, which frankly identifies and acknowledges areas that need to be improved. And I look forward to a fruitful discussion with the delegation with a view to assessing the progress made since the last review in 2008, as well as in identifying the remaining challenges to ensure the compliance of domestic laws and practices with the requirements under the Convention. Mr. Chair, the United States of America is one of the most multiracial and multi-ethnic societies in the world. And since the election of President Obama in 2008, the state party has taken commendable steps towards efforts to promote racial equality. However, as noted in the state party report itself, the path towards racial equality has been uneven. Racial and ethnic discrimination persists, and much work remains to be done. To meet the goal of ensuring equality for all, and today, I would like to highlight some of these areas of concern which have been identified in the list of themes that has been transmitted to the state party delegation in July, as well as additional issues of concern in the light of recent developments and information received from civil society organizations. I would like to express my appreciation to the representatives of civil society organizations who have committed their time to submit extensive reports prior to the dialogue to inform the committee, and also for their presence today. The sheer number of civil society reports that have been submitted in a testament to the diverse and vibrant civil society that exists in the United States of America. And I hope that this state party will continue to engage in meaningful dialogue with these representatives to continue to find solutions to ensure equal justice and equality for all. Mr. Chair, I would like to address an issue that has been addressed previously by the committee, namely the definition of racial discrimination in domestic law. As the delegation is aware, in accordance with Article 1, Paragraph 1 of the Convention, the state party is required to prohibit and eliminate racial discrimination in all forms, including legislation and practices. They may not be discriminatory in purpose, but in effect. However, I am concerned at the lack of progress since the last review, given that establishing race discrimination violation of the United States Constitution continues to require proof of discriminatory intent, and the scope of the application of the disparate impact doctrine remains limited. Could the delegation clarify whether this doctrine applies beyond the fields of employment, housing, and voting procedures? Could the delegation also provide some recent cases where courts have found violation of the disparate impact doctrine? And in addition, what kind of recourse to justice is available for victims who face indirect discriminations in fields that are not covered by the disparate impact doctrine? Does the state party intend to adopt comprehensive legislation at the federal level which would prohibit indirect discrimination in all fields of life? In its last concluding observations, the committee also expressed concern with regard to the lack of prohibition of racial discrimination committed by private individuals, groups, or organizations, such the broad reservation in Article 2. In this regard, the state party's report assets the continued need for this reservation, and that sphere of private conduct lies beyond the proper scope of governmental regulation under U.S. law. While I note that discrimination by private individuals, groups or organizations in areas such as the sale or rental of private property, employment at private businesses, admission to private schools, and access to public facilities is prohibited under the Constitution and federal laws, and what kinds of protection exist beyond these fields. Given the unique federal structure of the United States of America, there are also challenges to ensure that the provisions of the Convention are respected throughout the state party at the federal, state, and local levels. And as the delegation is aware, international human rights treaty obligations are binding upon the state party throughout its territory and jurisdictions under its effective control. And thus, it is important that laws and policies at the state level are also in conformity with the provisions of the Convention. And while I take note of the information provided in the State Party report concerning federal and state institutions that monitor human rights, as well as the establishment of interagency equality working group, the concerns expressed by the committee in its previous recommendation still remains regarding the lack of appropriate and effective mechanisms to ensure a coordinated approach towards the implementation of the Convention. To ensure compliance of domestic legislation and policies with international human rights obligations in a sustained manner, many states have established an independent national human rights institution, the NHRI, and following the Universal Periodic Review in November 2010, the United States government accepted recommendation number 74 to consider the establishment of a national IRI. What has been the progress in this regard? Does the state party have any other plans to establish a permanent institution tasked with monitoring and implementation of international rights treaty obligations throughout the state party on a permanent basis? Moving now in the issue of special measures, what is more commonly referred to as affirmative action in the United States. Could the delegation comment on the implication of the Supreme Court decision of October 2013 issued the Coalition to Defend Affirmative Action, which upheld the 2006 Michigan voter referendum that amended the state's constitution to limit affirmative action in public employment, public education, and government contracting. And I am also concerned at the measure passed in each state against the use of affirmative action in school admissions, which has reportedly led to drastic decreases in minority enrollment. Could the state party comment on these developments and clarify what additional measures are being taken or are being envisaged to counter the possible effects of these measures? With regard to the prohibition of racist hate speech and the reservation to Article 4 and 7 of the Convention, the view of the state party and the importance given to the rights of freedom of expression and freedom of association is well known. However, as the committee has elaborated in its recently adopted General Recommendation number 34 in 2013 on combating racist hate speech, the committee takes a very careful approach in protecting the legitimate right to freedom of expression in the one hand and ensuring the eradication of incitement and discrimination on the other, though the mobilization of the full normative and procedural resources of the Convention, including not only Article 4, but also Article 5 and 7. And the committee has also emphasized in the general recommendation the necessity of analyzing contextual factors when determining the appropriate response to instances of racist hate speech, which can vary in gravity, such as the content and form of speech, the economical, social, and political climate prevalent at the time of the speech, the position of or status of the speaker, the reach of the speech, and the objectives of the speech. And in the light of the nuanced approach of the committee expressed in this general recommendation, I would urge the state party to consider reviewing its position. However, given the current lack of legal regulation of racist hate speech except for instances amounting to incitement to imminent violence, and the number of non-legal measures highlighted in the state party report to tackle this issue, and could the delegation elaborate on the impact of such measures in reducing instances of racist hate speech? And in the view of the state party, have instances of racist hate speech increased or decreased since the last review in 2008? Could you provide also us with the relevant statistics? I would like to turn to issues related to discrimination against national or ethnic minorities, particularly in relation to the criminal justice system, including in relation to juveniles' education, voting rights, the use of racial profiling and surveillance by law enforcement officials, excessive use of force by law enforcement officials, and gun violence. I welcome the acknowledgement in paragraph 65 of the State Party report that while laws and systems are in place to ensure quality of access to and treatment in the criminal justice system, racial and ethnic disparities continue to exist in the criminal justice system. Indeed, I'm concerned at the persistence of racial disparities throughout all stages of the criminal justice system, including overrepresentation of individuals from minority communities, in particular African Americans, among persons who are arrested, charged, convicted, incarcerated, and sentenced to life without parole, especially for non-violent offenses, as well as sentenced to death. And while I welcome the enactment of the Fair Sentencing Act in 2010, which reduced the disparity between the more lenient sentences for powder cocaine charges and more severe sentences for crack cocaine charges, which are more frequently brought against minorities, I remain concerned that racial disparities in sentencing have not been eliminated. I'm also concerned at racial disparities in the use of prosecutorial discretion, the application of mandatory minimum drug offense sentencing policies, and the implementation of repeat offender laws. Can the delegation clarify what steps are being taken in these areas? In paragraph 20 of the 2008 concluding observations, the committee recommended that the state party undertake further studies to determine the nature and scope of the problem of racial disparities in the criminal justice system, and to implement national strategies, plans of action aimed at
la mise en œuvre de stratégies et de plans dans l'application de la peine de mort. Il s'agit aussi de préparer des stratégies efficaces dont l'objectif est de mettre un terme à toutes les pratiques discriminatoires possibles, à entreprendre des mesures pratiques et législatives, à prévenir le racial dans le système de la justice pénale et à réviser les sentences
on racial and ethnic minorities. Could the State Party provide information on progress achieved in these areas as well as their impact? Racial disparities in the treatment of minority youth in the criminal justice system is also a continuing matter of concern, particularly with regard to the disproportionate rate at which racial minority youth are prosecuted as adults, incarcerated in adult prisons, and sentenced to life without parole. While the State Party report refers to the Juvenile Delinquency Protection Act, I understand that the legislation addresses youth in the juvenile justice system and does not apply to youth who are tried and incarcerated in the adult criminal justice system. Could the delegation clarify what measures are being taken to encourage states to reform laws that allow or require youth to be tried as adults, which has a disproportionate impact on minority youth? With regard to juvenile sentence of life without possibility of parole, I welcome the Supreme Court decision in Graham, Florida, which held that the application of juvenile sentence of life without the possibility of parole to juveniles who commit non-homicide offenses violate the Constitution's provision against cruel and unusual punishment, as well as the decision in Miller v. Alabama, which held the sentencing schemes that mandate life imprisonment without parole for those under 18 at the time of their crimes is unconstitutional. However, I note that despite these rulings, discretionary life imprisonment without parole sentences are still allowed, and that 15 states have not yet changed their laws to comply. The Department of Justice in 2011 to increase diversity and eliminate discrimination in schools, and the $100 billion commitment to find the Race to the Top program and financial aid for post-secondary education. Could the delegation inform the committee on what actions have been taken following the recommendation of the Equity and Excellence Commission? What additional measures are being taken to enforce the federal requirements to ensure equitable assignment of teachers into poor and minority students, equal access to core curriculum and college preparatory classes, and fair and effective disciplinary policies and practices? With regard to the right to vote, I remain concerned at obstacles to voting imposed on individuals belonging to national or ethnic minorities, including voter identifications laws, district gerrymandering, and disenfranchisement of convicted felons who are disproportionately from minority backgrounds. And in addition, it is worrying that in the Shelby Harder decision of June 2013, the Supreme Court struck down Section 4 of the Voting Rights Act and made Section 5 of the Act inoperable, thus undermining the procedural guarantees in addressing racial disparities in the right to vote. And I am concerned that several states have passed restrictive voting laws that increase obstacles for disadvantaged minority communities to exercise their right to vote. What measures are the State Party taking in the light of these developments to ensure that there is no undue burden for individuals from minority groups to vote? What specific measures are being taken to ensure the convicted felons are able to exercise their right to vote throughout the state party? Another ongoing issue of concern is the continued use of racial profiling, including stop and frisk policies, as well as surveillance by law enforcement officials targeting certain ethnic minorities, including the surveillance of Muslims. Muslims by the Federal Bureau of Investigation and the New York Police Department. While I welcome the position of the state party that racial or ethnic profiling is not effective law enforcement practice, I remain concerned that there are still broad exemptions in the prohibition of racial profiling for practices related to the protection of national security under the guidance of the use of race by federal law enforcement, which allows also for investigative stops and searches within 100 miles of national borders without cause. Could the delegation clarify whether any steps are being taken to narrow or eliminate these exemptions to racial profiling in the guidance? Has a data collection system been introduced in all law enforcement agencies to record and document instances where individuals are stopped, searched, or questioned in order to identify cases and trends of racial profiling and to hold those responsible accountable? Given that the state party also accepted Recommendation 68 and 219 following the Universal Periodic Review process to take legislative and administrative measures to ban racial and religious profiling in law enforcement. Could the delegation update the committee or any progress made, including the status of the End Racial Profiling Act? Continuing on which the conduct of law enforcement officials, I also remain concerned at widespread reports of abuse conduct and excessive use of force by law enforcement agents against persons belonging to ethnic or racial minorities, in particular Latino and African American persons, and undocumented migrant crossing the United States-Mexico border. I am also concerned that the number of individuals, majority who are of Hispanic descent, who have been injured or killed as a result of the use of excessive force by United States Customs and Border Protection and the lack of investigation, prosecution of those responsible, and the provision of effective remedies to the victims of their families. Could the delegation please clarify what percentage of cases involving abusive conduct and excessive use of force by the Customs and Border Protection agents have led to investigations, disciplinary or prosecutory action, and provision of remedies to victims or their families? I would like also to express my concern with regard to high levels of gun violence in the state party, and its disparate impact on minorities. According to information received, African Americans make up 13% of the population, but 50% are homicide victims, of which 82% are committed using firearms. African American males are reportedly 7 times more likely to die by fire homicide than their white counterparts. And I do understand that these disparities arise from factors and subconscious racial bias in shootings. in shootings. The proliferation of your ground laws, and the existence of predominantly African American and economically depressed neighborhoods with escalated levels of violence. Could the delegation provide further information on the underlying causes on the disparate impact of gun violence, as well as concrete measures taken to reform gun control laws? What measures are being taken to address the discriminatory effect on stand your ground laws? Discrimination against non-citizens, and with regard to asylum seekers, I'm concerned. I'm concerned they, together with other vulnerable persons, are detained for a prolonged period of time in prison-like facilities with inadequate health care and treatment. In 2013, it allegedly took on average 111 days to process claims for asylum, despite the 10 days deadline mandated by federal law. Can the delegation clarify what measures are being taken to address these issues? These issues including any steps taken to consider alternatives to detentions. In the absence of comprehensive immigration reform legislation and the continued enforcement of stringent immigration law, I know that more than 2 million persons have reportedly been deported from the state party since President Obama took office, which is more than any other administration in the same period of time. And I'm concerned at the number of immigrants who are deported through expedited removals or reinstatement with no hearing before an immigration judge, particularly given the surge in unaccompanied children who have recently arrived in the southern United States border. Could the state party comment on the effectiveness of the measures taken so far in addressing these issues? Discrimination against indigenous people. Well, I welcome the efforts by the state party to address challenges facing indigenous peoples, including support for the United Nations Declaration on the Rights of Indigenous Peoples, high level of conferences organized by President Obama with more 350 tribal leaders, and efforts to promote the culture and tradition of American Indian, Alaska Native, and Native Hawaiian peoples. The plight of indigenous peoples remains a serious matter of concern, and these include disproportionately high level of suicides, unemployment, violence against women, which is the highest among all ethnic or racial groups in the state party, as well as expropriation of ancestral lands and lack of respect of treaties signed between Indian nations and the U.S. government. And I am also deeply concerned at high rates of post-traumatic stress syndrome among the population in Alaska. Can the state party provide concrete information on the measures taken to combat these issues, as well as on their impact? And with regard to violence against women, while the tribal law and other act of 2010 has increased the length of sentences tribal courts can issue in criminal cases, and I'm concerned that the rejection only extends to those who live or work on the reservation, or to those who are married or are in partnership with a tribal member. Similarly, I note with concern that the Violence Against Women Act of 2013 covers only certain domestic violence crimes, but does not include crimes of rape, stalking, or trafficking in Native American women. Could the delegation, therefore, clarify how crimes committed on reservations, especially violent crimes committed against indigenous women, are effectively investigated and their perpetrators brought to account and victims provided with appropriate remedies? Additionally, I'm concerned at the large number of tribes that remain unrecognized by the federal government and the obstacles to recognitions, such as the high cost and lengthy and burdensome procedural requirements and ongoing problems to guarantee the meaningful participation of indigenous peoples based on their free, prior, and informed consent. Can the delegation provide concrete information on what measures have been taken to facilitate the recognition of tribes, guarantee the requirement of free, prior, and informed consent of indigenous people for matters that affect them both in law and in practice, as well as the justice mechanisms used to provide appropriate remedies for adverse economic activities by corporations, and how meaningful participation of indigenous communities in the determination of appropriate remedies is guaranteed, while taking note of the information contained in paragraph 177 of the State Party report. Could the delegation clarify what concrete legislative and practical measures have been taken to ensure the accountability of American corporations that operate both nationally and abroad adversely affect the rights of indigenous peoples and ethnic minorities? The access to justice, and while the Sixth Amendment of the Constitution of the United States guarantees the right to counsel in federal and state criminal proceedings where the defendant faces a prison term of a year, I'm concerned that there is no right to counsel for civil proceedings, which include deportation procedures, which disproportionately affect indigenous individuals from ethnic and racial minorities. And I am also concerned. I am also concerned at inadequate or unavailable counsel for indigent individuals from minority communities in criminal proceedings in practice, as recognized by the State Party in paragraph 62 of its report. Also noting that the rising fees and fines associated with the criminal justice system has been increasingly assumed by defendants, what is the State Party doing to ensure that all indigent individuals have effective access to counsel in both civil and criminal proceedings? And I am also concerned that despite the commitment made by President Obama to close all detention facilities at Guantanamo Bay, and the reiteration of this commitment following the Universal Periodic Review in 2008, foreigners continue to be detained and denied access to justice. Can the delegation comment on the lack of progress achieved in closing the detention facilities at Guantanamo Bay and concrete measures taken to ensure that all detainees have prompt and effective recourse to justice? My concluding remarks, Mr. President. Given the limited time available, I do regret that I have not been able to address all the issues of concern as identified in the list of themes, including issues such as racial disparities in health and access to health care, exposure of low income and minority communities to high levels of environmental pollution, criminalization of homelessness and access to housing, the situation of migrant workers, and the effectiveness of training and other measures to combat racial discrimination. And however, I trust that my colleagues in the committee will be raising them during the dialogue. Mr. President, I look forward for receiving the response from the delegation on the question raised above. And thank you, Mr. President, Mr. Ambassador. Thank you very much for listening. Thank you.
Muchas gracias a usted, señora.
I thank you very much, Mr. Amir. I have a number of colleagues on the list of speakers. Mr. Murillo Martinez, followed by Mr. Diacono. Mr. Murillo Martinez.
Gracias.
Chair, thank you. Mr. Chairman, it is very good to see two indigenous citizens presiding over the dialogue this afternoon. I also would like to note the active and constructive and coordinated participation of the non-governmental organizations in this review of the United States of America before the CERD. I'd like to voice my thanks to Mr. Amir, the Special Rapporteur, for his comprehensive analysis of the situation. It's a shame that my colleague and friend, Mr. Vasquez, who knows the situation best of the US, given to obvious reasons, cannot be actively involved in this discussion this afternoon. On the 11th of March, a judge from Louisiana ordered the release of Mr. Glenford after having demonstrated his innocence. Mr. Glenford is a black person, and since 1988 he was on death row. In other words, he stayed on death row for 26 years. He's 64 years old today. Beyond the rejection or the controversy surrounded by the heinous practice of the death penalty for the case introduced by the Great Britain around the 1600s, this questions the observance of the principle of equality before the law, which, inter alia, manifests itself through structural discrimination, through the habitual use of racial profiling, and as a product of indirect incrimination. In the United States, since out of the 140 prisoners who've been found innocent over the last decades, who were given a death sentence, I'm looking at the last 30 years, and who waited rather 30 years on death row, most of these are Afro-descendants. Up until 2008, 42% of the people on death row were black. There's a downward trend, but in 2001, 50% also were black. The present disproportionate presence of an ethnic and social group in a criminal system is one of the most eloquent signs that there is structural discrimination. In this respect, the CERD has reasoned. Thus, when the indices, proportionately high indices of delinquency attributed to people belonging to those groups, especially linked to small petty crime and drugs-related crime and prostitution, are an indication of exclusion and non-integration of these persons into society. Similarly, it's been indicated that the number and the percentage of the people belonging to those groups that are found submitted to criminal or administrative detention, including in internment, or penitentiary centers or psychiatric centers or other holding areas in ports, etc., also corresponds to the aforementioned circumstances I referred to. According to official figures provided by the report of the State Party, the population of Afro-descendants represents 13% of the population, but in 2008 poverty affected 24.7% of Afro-descendants in the US, but to the whites ratio for the same year is 11.2%. The non-Hispanic incarceration rates was 6 times greater for black people than for white prisoners, namely 3 times the number of white or Latin Americans. Also, 1 of every 730 black women were in prison, compared to over 1,900 whites, and comparable figures for the Latinos. Around 1.7 million children, minors, who have parents who are in prison. The state itself also has recognized this. The right to vote, or the full exercise of the right to vote, has been seriously undermined for the prison population. In contrast, in 2007, over the 60,000 judicial officials in the state and federal courts, only 1,751 were from African descent, which represents around 3%. The use of racial profiling, which is habitual, well, you will recall yesterday in this very room, we were really pained to hear a father describe the situation in which his 17-year-old son, Jordan David, was killed just because he was black, at the hands of one of the hundreds of thousands of US citizens who have a license to bear arms and who believe that they have a license to kill for all intents and purposes, to kill any person who seems to be suspect to them, and as far as they're concerned, many people, just because of their skin color, are part of that category of suspects. Another one of the participants yesterday here described to us a long list of, in inverted commas, sisters who have been victims of this practice by police authorities, this practice that violates human rights. In the case of the death penalty, whilst it is timely to point to the recent measure to not to apply it to minors or people with a mental disability, the committee hopes or waits to hear with great interest information from the US delegation with regards to the specific cases or measures that the US is intending to adopt to reverse that situation. Child labor now. I was surprised to hear yesterday a number of alarming figures with regard from NGOs that attest to the existence of a very high number of cases of minors who allegedly are forced to work, specifically from the Latin American and the Afro-descendant communities. I'd be grateful if the US delegation could provide more indications on this. With regards to the indigenous peoples now, Mr. Chairman, the fundamental right to prior informed consent is one of the most effective mechanisms to ensure independent development of ethnic groups. We should recall this. On the 1st of July 2009, President Obama edicted an executive order for the right of prior informed consent for indigenous peoples. Whilst such a measure does not possess the force of law, it is hoped, however, that the civil officials, public officials, will abide by it. However, in the words of the spokespersons of the indigenous peoples here, it would appear that this measure is not abided by the US state civil officials. What is the view of the delegation on this? Going back to populations of African descent, in 2009, the US, after initially having adopted an attitude of opposition to the matter, finally opted to support and even to us to co-sponsor Resolution 64169, whereby the General Assembly of the United Nations proclaimed the 2011 as the International Year of the People of African Descent. This initiative was celebrated by the CERD, as was fitting, and at the time, the original idea gave rise to the proclamation of an international decade for Afro descendants, which will begin in January 2015. To date, a plan of action is being put together to celebrate this decade. In the negotiations, everything indicates that the US should play a crucial role on this. So, on that particular matter, we would like to know from the US delegation here this afternoon what are the actions which the US government is carrying out in this endeavor to recognize justice and development to the people of African descent in the whole of the region of the United States, and especially the African diaspora. In fact, following the path laid down following the proclamation of the Afro-Descendant Year, the US delegation could consider strengthening its role to design, if it deems fitting, to adopt an executive order to increase international cooperation for the well-being of Afro-descendants, which would give an eloquent response to the over 200 million persons who, just in America, are delighted to see Obama having been elected, a man who was able to overcome racial barriers and is the object of so much hope. Mr. Chairman, I hope that we have an opportunity this afternoon and tomorrow to have an in-depth dialogue with the US delegation, and once again I thank them for their presentation.
A usted muchas gracias, señor Murillo.
Mr. Murillo, thank you very much. As I said, turning to Mr. Diaconou, followed by Mr. Aftonomov. Mr. Diaconou, you have the floor, sir.
Je vous remercie, Monsieur le Président. Thank you for giving me the floor. I'd like to know, first of all, the constructive tone of the report of the United States of America, if I compare it with the report we received during the previous consideration of the US report. I'd like to note also the preoccupations and a lot of measures taken by the State Party to respond to our comments in the previous concluding observations. Even on special measures, where there were some differences of opinion between the Committee and the United States, there is a positive approach. There are also examples and considerations justifying special measures taken by the United States of America. But the report we received from the civil society show that there is still an important number of cases and situations of discrimination based on race, color, and ethnic origin. Even the Department of Education mentions as receiving in 2011-2012 some 15,000 complaints, and more than 4,000 of them allegations of racial discrimination. In other fields, examples are also given in the report. About the federal state. US is a federal state as other some 20 federal states in the world. According to reports of the civil society, they present in different parts of the country specific types of violation of rights of communities of a different race, color, or ethnic origin as situations of racial discrimination. And I'll mention some of them. The situation of homeless youth of color in Chicago, public school closures in Chicago, pollution in New Mexico, lack of access to water in Boston, environmental injustices in Illinois, in Richmond, California as well, the management in Detroit. The periodic report presents a long series of mechanisms and structures in paragraph 28 of the report, competent to revise, amend, or annul governmental, national, or local laws, regulations, and measures. Why all these structures could not solve these situations, and probably the situations are not all. For all these situations, we consider the US as a federation responsible under the ICERD to fulfill its commitments, and the Federation is responsible according to a principle of international law. This is confirmed by the US Senate statement when it ratified the Convention in 1994. The Senate's advice and consent is subject to the following understanding, which shall apply to the obligations of the US under this convention, and I am citing, that the US understands that this convention shall be implemented by the federal government to the extent that it exercises jurisdiction over the matters covered therein, and otherwise by the state and local governments. To the extent that state and local governments exercise jurisdiction over such matters, the federal government shall, as necessary, take appropriate measures to ensure the fulfillment of this convention. End of citation. For us, the US Federation means not only government, but also the Congress and the judicial system with the Supreme Court on top. Some reports state that the convention is not known in the 50 states, similarly to our concluding observations. I read in the core document of the United States of 2012, in paragraphs 141, 146, different channels for obtaining and receiving information, giving information about our convention, including about other documents on human rights, including such volumes at the disposal of all local institutions, all local officials. So how can we explain the situations and acts of discrimination which are reported, and the explanation which is given by some of people that the convention is not known in different places of the United States? How should a federal state act for the implementation of the convention throughout all the country, a big state as the United States? It is difficult to give a recipe. There seems to be a lack of coordination of efforts. Some efforts are partial. They do not cover all the territory. The distinguished Attorney General or Alcázar mentioned today a project accepted by him and other 25 fellow general prosecutors. But this is only for 26 states in the United States. What about the others till 51? So, as I said, it is difficult to give recipes, but there are other countries, federal states closer to the United States, Canada, Australia. Maybe you could find good practices. For instance, there are reports about Arizona racist laws. What can be done to redress that situation? Is that issue covered by the measures, by paragraph 82 of the report about measures taken to repeal these laws, or there are other Arizona laws? The report presents many cases where the federal bodies, mostly the Civil Rights Direction of the Department of Justice, obtained the modification of local regulations, either by challenging them in courts or by concluding agreements with the respective institutions or units. It is very interesting to hear about this practice of agreements between a central institution and local institutions of the United States. My questions would be, what is the validity of such agreements? For how long are they valid? For how long are they applicable? How many cases are still waiting to be taken out under such practices? My view is to conclude that the state parties should improve the system in order to ensure the implementation of the convention throughout the territory, and as much as possible to prevent situations of discrimination. There has to be a more systematic approach, because by now there seems to be an approach from case to case when the fire is starting, and that is all, not a systematic approach throughout the territory. Second, about the special measures. I am glad to note a positive approach of the United States as to the special measures. A special measure is mentioned with regard to higher education. and is justified by the circumstances commanding by the superior interest of the US to promote pedagogic advantages linked to diversity. I noted on purpose this justification, and I think it is good to note it. But while welcoming such an approach, one cannot fail to note that such measures may be necessary in primary and secondary levels of education also in many places of the country, in the fields of housing, of health, of water facilities, or in favor of vulnerable groups or individuals. The committee could recommend that the state party consider adopting special measures in all fields, in circumstances making them necessary in favor of the communities of persons belonging to racial or ethnic groups. One can find that there are different court decisions and decisions taken by authorities in different parts of the country concerning special measures. The practice is very difficult. There is back and forth with these special measures, and one can notice that any time as such measures are taken, there is an offensive against them, and many of them are dislocated. So this leads to my mind to uncertainty, to legal uncertainty in this field, for the children first, for their parents second, for the system of education as a whole. So one should look at this issue and try to find a better solution. As to cases of pollution in areas where minority groups live, several reports refer to such cases. Pollution caused by industrial and extractive industry in New Mexico, pollution by industries in Illinois, Chevron oil refineries in Richmond, in California, the pollution hurting the Vietnamese community in Louisiana. So, reports refer clearly to environmental risks for minorities. It is obvious, even the state report refers to such environmental risks for minorities. It is obvious that such situations create a risk for health and life of members of such communities. Of course, many such situations may not have been created intentionally by the state authorities. Some of them may exist before the conclusion of the convention, may have existed before, even before the evolutions on human rights which we are living with. But such situations exist today, and they affect human rights of a community of people belonging to a minority. Therefore, the state cannot be indifferent to that. There are modern technologies limiting pollution. The state has to find a balance between the interests of the industry and the right to a healthy environment of peoples and communities. I have to add one concern about the cases of pollution in foreign states produced by US multinational companies. These situations are also to be considered as discrimination under our convention, being detrimental to people and communities of a different national or ethnic origin. As it is not acceptable in the US, it should not be acceptable on other territories. The Human Rights Council and OCDE dealt with this issue and adopted recommendations. The committee should continue to insist on these issues. And the paragraph 144 of the report of the State Party is encouraging us in this field. But practical efforts are necessary, as well as the statement in paragraph 177 says it. Access to justice. Reports reveal that there are direct and indirect limitations to access to civilian justice. We are told that people who lost their houses have difficulties to challenge such decisions in court, as well as for cases of termination of parental rights, deportation procedures, termination of social benefits and employment, because of difficulties to have a counsel. There are pilot projects like those in New York City, which are considered very positive, which would function well, but not in other parts of the state. It seems that programs and resources meant to respond to this problem are not sufficient, and they should be compelled. Question: what is the government doing to expand and improve access to services of legal assistance for civilian justice in order to make remedies provided for in Article 6 of the Convention available to more persons interested? Reservations of the United States. One has to take into account the changes adopted in the legislation and practice of the US since 1994, when the ratification and the reservations were made, came out. I will mention two examples as changes. The laws adopted since, which cover racial discrimination, in the private sphere, in almost all fields, and those which cover indirect discrimination for communities on grounds of race, color, or ethnic origin. And second, the law concerning the crimes of hate, which brings it closer to part of Article 4 of our Convention. As for Article 4, I would like to mention Recommendation 35, to which Mr. Amir already referred, and to recommend it for study, because it is a very balanced recommendation between the freedom of information and the freedom against racial speech. And it can offer a good solution for defending both social values, which are freedom of expression and freedom of racial speech. So, if I understood correctly, we are in a process in the United States. Our committee took always pragmatic position concerning reservations. We engaged in dialogue with state parties, we look at regulations and practices, and recommend to strengthen their efforts to implement the provisions of Article 4, taking into account the social needs of their population, in this case of minority communities of the country, and accordingly to consider withdrawing reservations or limiting their application. I associated myself on this issue and others with comments by Mr. Amir and other colleagues. Thank you very much.
A usted muchas gracias.
Thank you very much, Mr. Diakonou. Mr. Aftonomov is next, followed by Ms. Crickley. Mr. Aftonomov.
Gracias, señor presidente, por darme.
Thank you, Mr. Chairman, for giving me the floor.
Прежде всего, я хотел бы поприветствовать.
First of all, I'd like to welcome the delegation of the United States, and just like Mr. Diakonou, I'd like to point out the constructive nature of the report, as well as express my gratitude for the fact that you have so many members of your delegation here, and I believe that the members of the delegation and the great number of people present here will help us have a fruitful dialogue. And we also like to thank the representatives of civil society for their information and the efforts that they made, which shows their interest in the implementation of our convention, and also the opportunities that civil society has in the United States to defend their rights and express their views. And I will switch to English, and I do hope that this will simply speed up our dialogue.
Grateful to Mr. Amir as well for his comments and for his report. I think he touched upon almost all questions, and my colleagues added more. So that's why I have quite a short list of issues that I may raise. But still, there are. First of all, I would like I'll be very grateful for all comments, any comments on the resolution of General Assembly number 67/154. It is just of 20th of December 2012, which is called Glorification of Nazism and Inadmissibility of Certain Practices that Contribute to Fueling Contemporary Forms of Racism, Racial Discrimination, Xenophobia, and Related Intolerance. This General Assembly resolution deals directly with what committee doing, and there are several references to the committee and to the ICERD. So that is why I was very disappointed that the United States was among only 3 states who voted against it, and I'll be very grateful for all comments because this resolution is very important for our work. Then the question of federally non-recognized tribes. I understand that it might be explained by historical reasons that there are some tribes or nations who are federally recognized. There are non-recognized tribes, but the problem is not to find explanations for this. The problem is how to eliminate discrimination, which raised from the division of indigenous peoples into recognized or non-recognized. Mr. Amir has already touched upon this issue, but I would like to add that there is a problem for those who left their communities for this or that reason, looking for job or studying in the university or elsewhere, and they are losing their status of people belonging to indigenous peoples. And there are some problems for those who, after a long period of living outside community, returning to it, just requiring of their original status, even though they were born there, and then after living somewhere else, they try just to be reintegrated into the community. So it's a problem. I will be very grateful for any comments and explanations in this field. Then the case of Guantanamo prison, which is also really a problem for our committee because they have foreign detainees, and almost 13 years after it opened, the prison of Guantanamo Bay still holds 149 foreign detainees. 79 detainees are cleared for transfer from the prison, yet remain detained. Executive Order 13, 567 calls for an annual committee review to assess the status of transfer efforts for any detainee who has been designated for transfer or conditional detention by the Executive Order 13, 492 review, and who has not been transferred. Has that committee yet met, and if so, what was its assessment on the status of transfer efforts for cleared detainees from Guantanamo? Then the second, what means are being undertaken to guarantee detainees' right to petition for the writ of habeas corpus, particularly in regard to detainees' right to counsel and recently imposed search procedures at the prison? Upon reflection of the first year of their operation, what steps are being taken to increase the transparency and effectiveness of the periodic review boards, specifically in regard to detainees' access to evidence used against them? So these 3 questions are interrelated. I don't mean just to go further. It's just a shared question. Then, reportedly, according to the mass media, especially internet and some mass media in the United States, there is a new wave of anti-Semitism raised in the United States. I'll be very grateful to all comments in this respect, because it's also important for our committee just to understand what is going on in the state party, and it's also a problem for everybody. Then, Mr. Amir, Mr. Diakonou, and Mr. Maria Martinez have already touched upon problems of the voting rights, but I have one more facet of these violations. I know that the controversial ID regulation actually affects first of all people of African descent and indigenous peoples in realizing their voting rights, because many pieces of identification are not recognized for their polling purposes. So, for example, those IDs emitted by the indigenous communities, as well as many other IDs. For example, I know that university ID and many others. I don't mean go further, but I know, and reportedly many Afro-Americans and indigenous peoples in the United States were and are affected, first of all, by this regulation. Understand that the majority of regulation are just dealing with the state legislation. But anyway, the federal government may do something if it is possible. Of course, I'll be very grateful for any comments or probably certain actions or explanations, or probably certain actions or steps have been already taken. And maybe we do not know about all this. Then I'll be very grateful to any comments, any follow-up comments and explanations on the West Shoshone situation. The committee maintains or has maintained dialogue for more than a dozen of years with the United States. Still, many problems are at the same level as in the end of the previous century. I mean, just the 20th century. So from that point of view, I'll be very grateful to any explanation in this field because the committee paid a lot of attention and just spent a lot of time just to understand what is the problem. But still, we do not have enough information, and as far as I understand, the progress is not very good in this field. But probably we have fresher information in this field. Then, of course, the very focused and very specific question on racial riots in Ferguson, Missouri, after the murder of a young man, Michael Brown. I think that everybody knows what I'm speaking about, and that's why I don't mean go further in this field. And the last question, it's just the discrimination in the field of education. Many people raise this issue, but I know that there is also lack of programs and lack of subjects in the school curricula, dealing with intolerance, xenophobia, and discrimination, and specifically with the enlightenment in the field of our convention. People do not know the convention not only at the level of their professional field, but I think it's important for everybody to know their rights, and specifically the convention, what the convention offers to the people to protect their rights. I know that curricula, it is local, it is within local government powers. Partially it's within the state powers, but I know that there are so-called soft power of the Ministry of the Education Department of the United States, just to change the situation, to have a very good to influence the situation with a very good impact and outcome. So if there are any efforts, or probably if there are plans just to make these efforts, I'll be very grateful to any information in this field. Thank you very much. Sorry for many questions.
No hay problema, señor.
No problem, Mr. Avtonomov. You know that when we have good questions to ask, we can take that time. Let me just remind the other colleagues that given the time used by our three colleagues, each and every one of the following speakers will have 6 minutes to put their questions. So, without further ado, Ms. Quickly, followed by Ms. Kemal, and as I said, 6 minutes, please. Thank you.
Thank you very much, Chair, and thank you very much, colleagues. Thank you to the delegation, and thank you particularly to Mr. Amir. Indeed, I'm not sure if there's a lot left to say or there's too much left to say, and I'll try to avoid my usual Irish approach, which is to speak quickly when I'm stuck in this sort of a situation. A number of the key points have already been raised, and I would like to reinforce and reiterate, in particular, the points made with regard to hate speech and with regard to General Recommendation 35 and your Article 4 reservation by both Mr. Amir and by Mr. Diakonou. In this regard, I've been quite alarmed at the reported increase in extremism and in extreme hate groups in the USA. It's reported that there are something like 939 such groups now, and a stat that suggests that there's been that 68% of hate crimes actually target African Americans. I would very much welcome hearing from you your direct steps, the direct steps that you consider taking to address this. And in this regard, and with regard to a number of the other issues that we're dealing with, I would also welcome some information from you with regard to how you are going about collecting disaggregated data. I'm conscious with regard to hate crime, having been involved myself at the time, of the role that the USA played in the OSCE in the beginnings of the collection of the hate crime material there. But I'm also conscious of that being work in progress and of the ongoing need for disaggregated hate crime data, not only disaggregated in terms of ethnicity and indigenous belonging, but also disaggregated in terms of gender and in terms of age, so we get to understand also what's happening for children. And I'm conscious of the need for disaggregated data in a variety of areas, with regard to health disparities, with regard to education disparities, and also with regard to homelessness. You yourself have pointed to the rights of non-citizens with regard to non-discrimination in paragraph 12, and in paragraph 14 you in fact prioritise the elimination of racial discrimination against citizens and non-citizens alike. So I'd like to posit the rest of my regards taking some consideration of that position that you have already taken in your report. With regard to children, and given the way in which these legacy questions have already affected groups in my own country, I cannot be concerned at the implicit and structural biases in the child welfare system. I acknowledge the progress that was made under the 1978 Indian Child Welfare Act, but point to a number of reports that we have heard with regard to the open representation of indigenous children in foster care, prevented from access to their culture and prevented from access to understanding their way of life and from full education with regard to, thank you, I know I'm going too fast. And secondly, I would like to point to concerning reports we have had with regard to biases in private adoption arrangements. I'm conscious also of the historical legacy and current impact of the boarding school arrangements and the impact that that continues to have on indigenous nations and tribes and peoples. And I would like to ask you about any plans to rescind laws with regard to these arrangements that may still be on the books, and also particular plans you have with regard to appropriate responses, remedies and compensations. Now, as an Irish person, I cannot but be conscious of the particular role of the USA as a country of migration. And indeed, I know from the names of some of you that some of you at least must have formed at one stage part of that diaspora, or some of your great-great-grandparents were part of that diaspora from my own country. And I'm very conscious also of that inscription on the Statue of Liberty, where you talk about looking for the poor and the wounded and the disregarded from other countries, and you seek to take them and turn them into the great nation that you have become. Now, I'm very concerned, I must say, at the way in which border crossing has become a criminal offence in the more recent past. And I have to say, and I don't mean to make a joke out of it, but I do feel that if this was a century ago, a lot of Irish people would never have gotten any further than Ellis Island, if they even got as far as Ellis Island in that regard. And I would like to very seriously ask you about why it is that you consider that border crossing has to become a criminal offence, why it should not be considered in the civil system, and why those people who do what a lot of your predecessors did 100 years ago, why they cannot have due access to representation and to bond hearings in order to make sure that their cases are adequately and properly considered. I fail to understand entirely why families and children are being held at border crossing points. And I really feel that it is extremely important that these things are explained to us. I acknowledge the current migration reform proposals. These are welcome. But I feel that pitting, as seems to be happening at the moment, pathways to citizenship against more efficient enforcement are neither useful for the migrating populations that are involved, nor for your country or for its future. And in that regard, I particularly would like to ask questions about what is referred to as the fence, but in effect has become a border wall, and as has already been pointed out, affects in a differential manner the indigenous populations on both sides of the border, but also has had a very direct effect, as indeed have had shootings and killings of people who are merely trying to make a living for themselves by moving from one country to another or to rejoin their families there. With regard to other aspects of migrants' rights, I'm particularly concerned, as has already been indicated, by the regulations which facilitate, in a way that wouldn't be facilitated in, for example, McDonald's, the employment of children in agricultural production or in agricultural work from the age of 10 onwards. And I'm aware that this disproportionately affects migrant workers in the migrant population, and also probably disproportionately affects indigenous workers who are migrating in that process. I would also particularly like to point to the H2/B visa process for guest workers, and to the disparities and to the particular way in which it is open to discrimination for migrants and for minorities. I would like to ask you why you would not consider addressing the issues that are implicit in it and that are hidden in it. For example, processes whereby all of the power belongs to the employer, so that the employer and the person, the employment agency, controls the visa, controls the right of the employee to move, which it means even in circumstances where an employee can be subject to the most abject discrimination in the place of employment, he or she, and I'm particularly concerned in this regard with regard to women, doesn't directly have the right to move. In effect, overall, I'm concerned with a militarized and criminalization approach to migration, and one which in effect minimizes the rights to almost nil of the people who are in that migration status. And I acknowledge in this regard that you made a UPR commitment to fair work for migrant workers. The employment rights of undocumented workers are an issue I would like you also to address in your questions, and furthermore, oversight of conditions, particularly for the guest workers, and differentials in the migrant children's employment. With regard to women, whom in my experience as migrant women, as women from minorities and indigenous women, suffer not just a double burden but a triple burden, discriminated against as we are as women, as migrants or members of a minority or indigenous group, and also as women who are members of a minority or indigenous group. I'm conscious, for example, of the progress, and the very good progress in my view, that is made through the Affordable Care Health Act, which expands Medicare for those most in need of it. But I'm conscious also that that's happening in 26 states. 3 are considering it and 21 have opted out. And of course the 21 that have opted out have among their population women, a number of women from minority and indigenous populations, and also migrant women who will be particularly vulnerable. And I would like to ask you whether you have any plans to ensure that the anti-discrimination section 1557, to ensure that the comprehensive rules under that are fully implemented and robustly enforced. I would also like to address the issue of reproductive health of migrant and minority women, and to ask you whether you have any plans to extend the Title 10 family planning program to those who don't qualify for Medicaid in those states which don't intend to make it available to them. I would also like to ask you whether there are any plans to extend Medicaid clinics in the areas which don't intend to go for the enhanced protection, and also how, with regard to the undocumented, whom I understand can't avail at all of any of the protections under either Medicaid or the ACA Act, what plans you have to ensure that their rights and the right not to be discriminated against, which you articulate so clearly in number 12 and number 14 of your report, how those are actually going to be vindicated. And I also have considerable concern with regard to the 5-year wait for migrant women in order to be able to avail of Medicaid. Colleagues have already mentioned the Violence Against Women Act limitations, particularly in Alaska. And I feel that this is a discrimination and an aberration that really does need to be addressed. And also, I've already suggested the need for gender disaggregated data. I'm conscious of the time and of the number of other colleagues who have plenty to say and a lot more accurately and more focused than me, but I couldn't let the couple of minutes go without also mentioning implementation, because I think all of our talking here is really just a lot of interesting words in this big room unless there is robust implementation. And I acknowledge the progress that has been made, and I acknowledge the approach that you have taken, and I acknowledge the ongoing dialogue that you're engaging in with us here this afternoon. But I think that implementation, and you mentioned already the Equality Working Group, which is in place, as I understand it, as part of the coordinating group that's required under the UPR. And for me, implementation, and I'm familiar with these from my own country and other places as well under the UPR, for me, implementation needs to go way beyond that sort of coordinating group, which is a very good idea, by the way, required under the UPR. And I would like to ask you whether you have any plans for an immediate interim measure, which is beyond coordination, but looks to participation, outcomes and impact, and a mechanism which partners all of the key agencies of the state, along with civil society organisations. And for a finish, because I know he's just about to bang the hammer, for a finish, I would like to say, for me, that partnership is crucial. It's not just about civil society organisations undertaking some of the work that the state can't do, but it's about civil society organisations having, in your sort of advanced democratic society, the right to dissent, the right to actually inform policy, and the right to partner policy. And in particular, in this instance, I'm talking about civil society organisations that represent minority groups, indigenous groups, and the most marginalised, who are the subject of the Convention for the Elimination of Racial Discrimination. I thank you for your time and your attention.
Muchas gracias.
Thank you very much, Ms. Crickley. I give the floor to Mr. Kemal, to be followed by Mr. Huang.
Thank you, Mr. Chairman. And well, we heard a most interesting and informative introduction by Ambassador Keith Harper and members of his team, and a rainbow delegation. So we really appreciate your presence and your contribution, and of course our rapporteur, Mr. Amir's comprehensive and masterful introduction. In 2008, when the United States appeared before us, we were on the eve of Mr. Obama's election as president, and this was a landmark event without precedent in the history of the United States, and we were all thrilled. Unfortunately, since then we have seen that a change at the top, no matter how significant it may appear, does not necessarily translate into commensurate progress on the ground. And the intentions, I must say, have been excellent. The intentions of the United States have been excellent in the field of racial discrimination and combating racial discrimination. But there are certain structural programs. We agree with the delegation's contention that the United States is a vibrant society and a lot of effort and progress is being made. But we have also seen that the hold of structural discrimination against the African American population is a very strong hold. And the unhappy condition, the disadvantageous condition of the indigenous Americans is also something to be noted. If you take any index, there you will notice a tremendous disparity between the Caucasians and the African Americans and the indigenous population in terms of per capita income, housing, access to education, health, life expectancy, female, what do they call it, at the time of birth, the mortality. So these are conditions which the state party will have to do its utmost to remedy. And well, this brings me to a very serious problem which I think has not been highlighted yet, and that is the growing disparity in the wealth and incomes of the haves and the have-nots. So the have-nots are, to a great extent, the African Americans and the indigenous population. And to remove that, you require higher taxes. So there's something that is, and I remember the time I was there 50 years ago in the United States. It coincided incidentally with the Reverend Martin Luther King's movement and his march on Washington. I think that was in '63, yes. And there was a term used at that time, and I think we are in danger of facing that, the deadlock of democracy, which means basically, and I think the people here understand, the people from the delegation, it's a question of how to tax sufficiently and voluntarily. I mean, how are the people going to accept all this? Now, just a few points I would like to mention. I'll try to adhere to your time request for the time limit, Mr. Chairman. Racial disparities in the criminal justice system, which have been mentioned, and the disproportionate representative of the African Americans in the criminal justice system. I'm glad to hear from the delegation that changes are being contemplated, and in such areas, for example, as mandatory life sentencing and certain other areas I won't repeat, but these are to be welcomed, and I hope that it will be possible for the state party to implement this. Now, if you wish to remove structural discrimination of any community, then you have to focus on education, and your programs overseas recognize this point. You offer scholarships, fellowships to people from all over the world under the, for example, I mentioned the Fulbright program, and people are, and this is enlightened self-interest. It helps the community that is offered higher education. At the same time, it helps the United States in the long run, because these people will be better citizens and more peaceful and so on, and they will also be well favorably disposed. So this is something which is definitely to be considered, and which means giving, as we call them special measures, you call them affirmative action. So special measures for the indigenous people and the African Americans. I think this is something which is very to be commended, and I hope you are able to implement this in spite of obstacles and challenges that you may face. In this, somebody mentioned about the problem in Chicago. I remember had during our briefings with members of civil society, and they mentioned to us that in the Chicago school system, the good schools are being merged with the weaker schools, with the result that quality has gone down, and this is to the detriment of the education of the African American population. I should like to point out that this is not going to work, and something should be done immediately to redress the situation by injecting money. And if the state authorities are not able to do it, then I think the federal government should step in, because ultimately the whole society is going to suffer if these people do not graduate and if they don't complete their education, and they'll become a permanent burden then as a result of this policy. So that's my now affordable health care act. Well, I think that was a major step forward, but now I am not so familiar with the system, but from what I understand is that only about half the states have opted for the system and half the states have decided for the time being to stay out. So several million people are not covered by this very commendable act. So could the federal government plug this gap somehow till such time as the other states pitch in and could the delegation enlighten us about this? How do you propose to do this? I won't go into further details because I think you know what I mean. People have mentioned the impact of pollution on the African Americans and the indigenous populations, and of course the need to get informed consent. And they've also mentioned a lot of the NGOs we met. They talked about how the sacred sites are endangered, and this hurts the sentiments of the indigenous people. These are all worthy of consideration. Now, all American citizens are entitled to equal treatment under the law. While I agree that each state has a right to protect its security against acts of terror, its methods should conform to the principle of justice and equal treatment. And I wasn't going to raise this matter, but I saw the Human Rights Committee has drawn attention to this matter, and this is about profiling and surveillance of Muslims. I believe society has a right to protect itself, no doubt about it. And no doubt that before the attacks of 9/11, there was laxity and the state did not notice the evidence that was before it. Yet, the overwhelming majority of a particular community is loyal to the host country. They have left their homes to seek freedom and economic betterment. It is against their interest, and I believe that they are fully loyal to the state party. So if they are suspected, some of them, would you not agree, they would become bitter if they are being suspected by the state party. So this is something which has to be treated with great sensitivity and restraint. And the Human Rights Committee, as I pointed out, has highlighted this problem and drawn attention in this regard. Mr. Chairman, I am conscious of the shortage of time. There's so much, and give the other speakers a chance to speak. Thank you, Mr. Chair.
Muchas gracias a usted, señor Kemal.
Thank you very much, Mr. Kemal. And I apologize, but I was about to ask you to finish your presentation, so everything's fine. I give the floor to Mr. Huang, to be followed by Mr. Lindgren. I would like to complete the list of speakers that I have now in front of me, the colleagues. We still have quite a few colleagues on the list, so please, 5 minutes. That'll be great if you can keep your presentations to 5 minutes. Thank you.
谢谢主席给我发言的机会，我会尽量简短一点，但是我的语速肯定不会像。
I will be very brief, and I'm sure that I cannot speak as fast as Miss Crickley speaks. She speaks like a machine gun. Chairman, I would like to extend a warm welcome to the delegation of the United States, headed by the Ambassador for Human Rights. We see a very diverse delegation coming from different areas of life. We do thank the delegation and other members of the delegation for their presentations and statements. I really appreciate the analysis that was made by our special rapporteur, Mr. Amir, and I'm convinced that all of this will help us carry out fruitful dialogue between the state parties and members of the committee on issues related to the implementation of our convention. I also would like to welcome and thank the NGOs from the United States and representatives of civil society as well. I welcome them here, and we have received a lot of information from these organizations and also received a lot of information in writing. Now, Chairman, the Special Rapporteur and other speakers already made some comments on the report and asked questions. I do support the views that have already been expressed. I shall not repeat them. I simply would like to make several comments on the situation of Asian Americans. First of all, on the selective abortion bans. Now, during the past several years, in several American states, legislative authorities operated on the basis of unfounded allegations that felt that American women of Asian origin give more attention to boys than girls, and all of this is being done under the pretext of the fight against discrimination on grounds of sex, and this is why some states have adopted what is called selective abortion bans. I will not make any judgments about the projects themselves, but I'd like to say that it seems that these bans only target American women of Asian origin, so this is a typical case of racial profiling. But these types of problems do not really reflect the reality of the United States, but at the same time, this will not make it possible for American women of Asian origin to enjoy fully their reproductive rights on equal footing with others. And on this problem, during the review in 2008, the committee already invited the state party to look into this problem in its concluding observations, number 33. Secondly, according to reports in the media, the Senate in California adopted in January of 2014 a draft CH5. According to this project, higher schools in California, the percentage of children of Asian origin is too high, so this number should be restricted. And this project has already raised some serious concern and anger from students and parents of children of Asian origin, because effectively this is an amendment of law 2009 adopted in 1996, and this law 209 prohibits directly to public American university to take race as a criteria for the selection of students. And according to some bloggers on the internet, if students of Asian origin had a promotion, it was related because they had better results and they behaved better, and this the reasons why they actually were enrolled into universities was because of their qualities and not because of any questions related to race. Therefore, the application of SCA 5 would be racial discrimination that would prevent students of Asian origin to enjoy their right to education, and this will also contradict Article 5 of our convention. So I would like to invite the government of state party to take into consideration this question and to monitor its evolution. Chairman, in conclusion, I would like to add that just like everyone knows, the United States like to play the role of a world's policeman in questions of human rights. And each year, the United States government spends great resources of American taxpayers to publish reports on the human rights situation in many countries. But it has never talked about the human rights situation in the United States. So we sincerely hope that the United States State Department will also publish each year a report on the situation of human rights in the United States that will reflect the real situation in the country. For example, what should be presented is the implementation of different rights, respect of different rights, indigenous persons, persons of different origins, Afro-Americans, Asian Americans, and others. And now, when we take a flashlight, we should not shed the light on the faces of others only. We should also look at ourselves. Now, just now, Ambassador told us that an American of an African origin was elected as the President of the United States. And the U.S. Ambassador is also of African origin. And all of this indeed shows that the United States have shown great progress in terms of the elimination of racial discrimination. But at the same time, we have to indeed note that in American society, as far as indigenous persons are concerned, or people of a different color, or foreign immigrants, and their rights have been violated from time to time, and this is indeed a reality, something that exists. And there have also been some very serious cases. In addition, if we look at relevant documents, we can easily see a somewhat unusual phenomenon. In a country that always talks about human rights, in a country that does not have a mechanism, a national mechanism on human rights in line with the Paris Principles, and in addition, it has signed or ratified just a handful of crucial human rights instruments. And this really is not something that a superpower should be doing. And as a result, I do hope that the State Party will take additional efforts in order to ensure that other countries look up to the United States. Thank you very much, Chairman.
A usted, señor Juan.
I thank you very much. Mr. Lindgren, followed by Mr. Lahiri. Mr. Lindgren.
Thank you, Mr. Chairman. Mr. Chairman, on a lighter note, I would remark that if some Brazilian journalists came into this room without being previously informed of what had happened in terms of listening to NGOs and so on, they would report back to Brazil that there was a session of U.S. bashing by CERD in this committee. But we know it's not the case, and I know it's not a surprise for the delegation itself that so many incisive questions have been put forward by my colleagues, and maybe one or two will be put forward, maybe even by myself. I would, first of all, like to thank very much the U.S. for a very good report. I would like to welcome this very impressive delegation. Impressive not only in terms of size, but also because its composition is proof of the advances that the United States have already achieved in the area of the elimination of racial discrimination. I believe this is something we have to take into consideration. And it's a very large delegation, like the other one in the previous examination we had in 2008, which was also very large. But this one is not frightening. The other one was different. So welcome to all of you. It's a pleasure to see you and to talk to you. The delegation and the composition of the delegation, I think, confirms the general impression one gets from your report. A very well drafted, frank document that presents important comments on every concluding observation of last CERD's examination of the U.S. Even though some members of this committee may not share your positions concerning some aspects of our convention, as for instance your explanation for the reservation on Article 4, one cannot deny that you have a point. It's difficult to say that what is written here in your report from paragraph 47 to 50 is not important. It is very important. And I share what was said by President Obama, the impression that in his speech delivered in Cairo, that suppressing ideas never succeeds in making them go away. And we also, I myself, have also grave concerns about how empowering government to ban offensive speech could easily be misused to undermine democratic principles. But I say this with a caveat. In my case, I favor the prohibition. I simply said that I understand the point of the United States. Your report, as well as some of the oral presentations of today, are very frank, full of illustrative cases. One aspect I could not fail to notice is that in many areas, what has been often interpreted as a result of racism, the problem in your own vision is not racial, but social. And this is the position that I tend to take in many occasions against the opinion of my colleagues who follow the common position of the American civil rights movement. That's strange. But anyway, it's precisely the United States that is giving support to Marx in this, that, well, poverty can be the worst case of discrimination of all. Since I said that the black movement in Brazil is inspired by the civil rights movement in the United States, and I use the word black, I would like to put a question to you. It's very unusual to see in any report a reference to black slash African descendants or African Americans. Do you see, is there any difference in terms of concept between the words black and African American? I don't know. I would like to know about it. I would also like to know what is the difference between Hispanic and Latino. I believe I am Latino, although I'm not Hispanic. But I probably for the United States I'm also Hispanic. I don't know. While the Spaniards are not. So it's very strange. Uh, uh, in fact, I came to this reference to the words because I said that, well, I can understand how banning some expressions or some ideas can be badly used, and instead of devoting our time to solving the problems, sometimes we devote too much too much attention to the question of words, and forget the real problem underneath. One of the most obvious cases for me is when the whites prefer to call themselves Caucasian. What do they mean? They become members of Armenia or citizens of Georgia? What is it? I never understood it. Doesn't it sound so similar to Aryans? How do you say that Hitler said? It's very similar. So in order to be politically correct, you sound even sometimes, not you, the American, but these people who are too much concerned about politically correct language. Well, having raised these almost funny issues to you, I will just stick to 2 points which are really serious. One of them, I will, although it has already been referred to by Mr. Amir, who made a very good introduction. I think if you reply to all the questions that he put, it is already a very good dialogue with our committee. But anyway, since last time I mentioned this point, I will mention it again. It was the question of juvenile life sentencing without parole, which affects mostly minorities. I know that in 2012 it has been declared unconstitutional by one of the cases that you had judged or tried in the United States. Still, I think that the report itself and the counter report confirm that it is still being used in several states. Isn't there a possibility to punish these states or to do something against this? How come that something that has been declared unconstitutional goes on like this? This is my first of the 2 questions. The other one is just a comment that I would like to hear from you. You have already also mentioned this in the report. You have also referred to this indirectly in the presentations of today. But I was stunned yesterday when I heard from a group of very able people representing civil society of the United States, NGOs that were present here, that the situation of segregation at schools in the United States is much worse now than it was in 1970. How come that this can happen? I know that it stems from the question of lack of funds. But isn't there something more than this in this decision to close some schools precisely in black areas, in Hispanic areas, in Latino areas, or Asian areas, I don't know, native areas, which are not of the so-called Caucasians? Oh, okay. And then just to make sure, I have the impression that you don't have it anymore. But I would like to know, because we all refer to affirmative action as quotas. And I know that you have affirmative action still, but I don't believe you have quotas anymore. Do you still have quotas in universities? I would like to know. Thank you very much.
A usted, señor Lin.
Thank you, Mr. Lindgren. Thank you for your typical way of putting questions. So far, this has been one of your best performances, sir. So, very grateful to your contribution. Mr. Lahiri, followed by Mr. Bosil.
Thank you, Mr. Chairman. Mr. Chairman, I don't think after the series of colorful speeches we've just had that there is any space for me to indulge myself. But I would like to express my appreciation to Ambassador Harper for his presence and that of his high-level delegation, and for the several important statements that were made by important persons from the Department of State, from Justice, from Education, from the Attorney General of Arkansas, the Mayor of Birmingham, and so on. It's the statement that was made and the report that has been put forward by us explained quite rightly the considerable advances and the progress that has been made in the United States in the field of human rights. And indeed, it's a matter of considerable encouragement. I'd also like to congratulate Mr. Amir, the rapporteur, for an excellent, comprehensive statement. Mr. Chairman, while the good points have been highlighted, there are weaknesses in the report, more of omission than of commission, of structural discrimination, of blurring the distinction of the federal and state responsibilities and so on, which one cannot say exactly is are contraventions of the convention, but certainly they do go against the spirit of the convention. And then, of course, we've had the series of reports and presentations from the large and very vibrant civil community, civil organizations who have some of whose presentations were really very touching and alarming. But they talked about the continuing segregation in housing, in education, where the affirmative programs at the university level certainly but have been dismantled. The criminalization of colored people, disproportionate punishment of colored people, forced administration of untried medicines in prisons among the large numbers of incarcerated colored people, then racial profiling and so on. All these will I'm sure appear in our reports and will no doubt provide the opportunity for the state party to refute and to explain what their position is. But we do need to, but the state party, I think one weakness that they could cure quite easily is in terms of better publicizing the text of the ICERD and of perhaps requiring periodic reports by their federal officials and lawmakers and local and state government officials on their implementation of the provisions of ICERD. I will associate myself with all that was said by my colleagues on these matters and not take up more of your time. But I would like to endorse what Ms. Crickley said about some attention that needs to be paid to the discriminatory treatment of guest workers, of this H2B category of guest workers, and the opening that the terms of their recruitment provides for trafficking, discrimination, and abuses by their employers. There should be some means of keeping a check on this, of preventing employers who have violated past contracts from continuing to recruit workers, from making sure that the terms of the contracts are fulfilled, and it's an important avenue for interaction between a large number of countries and the United States, and I think this is a matter which requires attention. Thank you, Mr. Chairman.
Thank you, Mr. Lahiri. Monsieur Possul is next, followed by Ms. Da, if we have time. Otherwise, we will continue tomorrow morning. Monsieur Possul, you have the floor, sir.
Thank you very much, Mr. Chairman. Mr. Chairman, I'd like, of course, to thank the delegation of the United States first for the report itself and then for the presentation of the report. I also thank Mr. Amir, who did wonderful work in making a synthesis and asking all those questions on behalf of us. And I also to thank the civil society, which was largely present here before and around our meetings, and which gave all this interesting information on the situation in the state party. I will concentrate my intervention on Team 6 of the list of themes. That's the training and education to combat prejudice and intolerance. And in fact, it relates to Article 7 of the International Convention on the Elimination of All Forms of Racial Discrimination. The first question is about the domestic status of the convention. As a professor of international law, I was always happy to read in Article 6 of the US Constitution that treaties are the supreme law of the land. It's a beautiful statement. But what about the direct applicability of the convention in domestic laws? Is it a general statement? What are the conditions? How is it for this particular convention? Is it provision by provision that it should be examined, or is there a position on the convention as a whole? Now, important is, of course, the reporting which has been presented to us, and that is based on coordination with a lot of departments, which are mainly based in Washington, I believe, and I am particularly happy that this time the state and local officials are also present here in Geneva to enter in dialogue with us. And I was also happy to read in the report that the US government is examining ways to improve human rights treaty implementation at all levels of government, which means, I believe, not only at the level of the federal government, but also at the level of state and local government. Despite all this, it's certainly true that many state and local officials are unaware of the treaties which are ratified by the United States and what are the obligations contained in it. So I think it would be useful if the concluding observations of the treaty bodies and also the recommendations of UPR would be largely disseminated also on the lower level of government. And so for that reason, I would like to make three recommendations. First, I think it would be good that education and training should be provided to state and local agencies on their obligations under the International Convention on the Elimination of all forms of racial discrimination, and that includes this dissemination of the concluding observation. And I think that guidance and technical assistance should be offered also to state and local government. Second, I think it would be good if a federal focal point should be ensured. Colleagues of mine referred already to this need, and a federal focal point that would coordinate with state and local actors regarding the human rights implementation of the treaties. And finally, my last point, Mr. Chairman, is that one should also maybe envisage to provide to state and local governments funding to engage in this human rights monitoring and implementation. It should not be left at the federal level and also go down on the lower levels of government. Thank you, Mr. Chairman.
Thank you, Mr. Bossuet. Ms. Da, turning to you. Do you want to take the floor now or tomorrow? Because if you take the floor now, it won't be fair on you because you won't have as much time. So tomorrow, yes, you appear to want to take the floor tomorrow. So distinguished colleagues, distinguished delegation of the United States, tomorrow morning we will begin, first of all, with the questions by Ms. Da and other colleagues who have asked for the floor, after which we will hear your replies, your comments to our questions and queries, and you will have 1 hour tomorrow morning to answer, as I said, the questions and queries. After your replies, we will have a further chance to have, well, a more interactive dialogue. So we'll put questions which you will be able to answer directly. So once again, thank you very much for your understanding and your patience. And with this, meeting 2299 is adjourned. Have a good evening, everyone.
Gracias, Chair. Thank you.